Good afternoon and welcome to the Public Service Commission of South Carolina. It is Wednesday, September 20th, 2023 at 2 p.m. and we are here for a rescheduled commission business meeting. We rescheduled the meeting from Thursday due to some absences on Thursday the 21st. So this takes the place of our regularly scheduled commission business meeting. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin and Commissioner Thomas, and present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. Before we begin with the agenda, I invite you to join me for a moment of silent reflection. Thank you very much. Good afternoon, Mr. Scarborough.
Good afternoon, Madam Chair and Vice Chair Powers and Commissioners. First item of business is to set the next regularly scheduled business meeting. Staff recommends that the next commission business meeting be scheduled for Thursday, September 28th, 2023 at 2 p.m.
We will schedule our next commission business meeting for Thursday, September 28th at 2 p.m.
Thank you. Today we have 15 items on the utilities agenda and just 6 items on our transportation agenda. Item number 1 appears in docket number 2023-301C. This is a petition from the Office of Regulatory Staff for waiver and amendment of the revised guidelines for the administrator and participants in the South Carolina Universal Service petition, and a request for confidential treatment of the petition.
Commissioners, we've heard utilities agenda item 1 is described by Mr. Scarborough. Do I hear a motion?
Madam Chair.
Commissioner Thomas is recognized.
Thank you. I move that the clerk's office combine this docket with docket number 1997-239C and place all filings in both dockets. I also move that the clerk's office issue a notice of filing with a procedural schedule for comments. I further move that the Commission grant ORS's request for confidential treatment of certain information. So moved.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Thomas. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Thomas.
Aye.
Commissioner Justin Williams?
Aye.
Vice Chair Powers?
Aye.
Commissioner Carol Lee Williams?
I vote aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
And the chair votes aye. The motion carries.
Item number 2 is in docket number ND-2022-30E. This is a request for a status update from the Renewable Energy Integration Studies Technical Advisory Team and a request to change and add the South Carolina Department of Transportation's designees to the team.
Commissioners, we've heard the utilities agenda item 2 is identified by Mr. Scarborough. Do I hear a motion?
Madam Chair.
Commissioner Irvin is recognized.
Thank you. I move that the commission take notice that we will be receiving a status update from the Integration Study Technical Advisory Team on or before October 6, 2023. Further, I move that the commission replace Justin Powell from the Technical Advisory Team and add Lynn Bramlett as a representative for the South Carolina Department of Transportation on the Technical Advisory Team. So moved.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Irvin. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Justin Williams.
Aye.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams.
Aye.
Commissioner Caston.
Aye.
The chair votes aye. The motion carries.
Item number 3 appears in docket number 2023-242E. This is Duke Energy Progress LLC's motion to dismiss the complaint in this document and request for confidential treatment of the redacted motion.
I think that's confidential treatment of the unredacted motion. Is
Yes,
that
ma'am.
correct?
Should be unredacted. Thank you.
Thank you. Commissioners, we've heard item Number 3, identified by Mr. Scarborough. Do I hear a motion?
Madam Chair, I have a motion.
Vice Chair Powers?
Thank you. I move that the commission deny the motion to dismiss and direct the clerk to reschedule the date for this matter to be heard by hearing examiner Alicia Clausen, as well as provide a procedural schedule for the submission of pre-filed direct, rebuttal, and sur-rebuttal testimonies and exhibits. Further, as Mr. Hebwin is the owner of the account and the only person allowed to request termination, Mr. Hebwin will need to participate in the hearing for his complaint to be considered. Mr. Hebwin may proceed as a pro se litigant, or Mr. Hebwin may hire his own legal counsel at his expense to represent him in his complaint. So moved.
Thank you, Vice Chair Powers. Commissioners, we've heard the motion made by Vice Chair Powers. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams?
Aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Commissioner Justin Williams?
Aye.
I vote aye. The motion carries.
Item number 4 appears in docket number 2023-70G, which is the Office of Regulatory Staff's motion to reopen the record in this docket on an expedited basis.
With regard to utilities, agenda item 4 is identified by Mr. Scarborough. Do I hear a motion?
Chair Belzer, I'd like to make a motion.
Commissioner Carol Lee Williams is recognized.
Thank you. I move that the commission reopen the record in docket number 2023-70G to receive the affidavit of ORS witness Daniel Sullivan, which verifies the correction of mathematical errors in the calculation of the company's overall decrease to margin revenue and the company's overall revenue requirement, resulting in an amended stipulation entered into by Dominion Energy South Carolina, Inc., the Office of Regulatory Staff, and the Department of Consumer Affairs, CMC Steel, South Carolina, IGS Energy, and Direct Energy Business Marketing, LLC. I also move that the Commission accept into the record the amended stipulation with amended attachments A and B, which correct a mathematical error reflecting the company's overall decrease to margin revenue of $5,127,991, or approximately 2.07% below current rates. The company's overall revenue requirement increase of $8,872,986, and which is a decrease of approximately $10,584,730 relative to the application filed by Dominion Energy South Carolina with the Commission on March 31st, 2023.
Thank you, Commissioner Williams. Commissioners, we've heard the motion from Commissioner Williams. Is there any discussion?
Madam Chair,
Vice Chair Powers?
I am recused from that case and will not be voting.
Thank you. We will note that on the record. Thank you, Vice Chair. Anything further, Commissioners? Hearing nothing further, we'll proceed to a roll call vote, starting with Commissioner Carol Lee Williams.
Aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Commissioner Justin Williams?
Aye.
And I vote aye. The motion carries.
Item number 5 appears in docket number 2023-294G, which involves Travis Hunt's request to withdraw his complaint in this docket.
With regard to utilities, agenda item 5, do I hear a motion?
Madam Chair,
Commissioner Caston?
I move that the Commission grant Travis Hunt's request to withdraw his complaint against Piedmont Natural Gas Company, Incorporated. No responsive pleading has been filed in this docket. South Carolina Code annotated Section 58.3.225E provides that a party may withdraw its complaint one time as a matter of right and without prejudice, provided it does so prior to the later of the date responsive pleadings are filed or the date the withdrawing party's direct testimony is due to be filed. I further move that the Commission's clerk's office cancel the hearing in this matter, as well as any pre-file testimony deadlines.
Thank you, Commissioner Caston. Commissioners, we've heard the motion from Commissioner Caston. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Justin Williams,
Aye.
Vice Chair Powers,
Aye.
Commissioner Carol Lee Williams.
Aye.
The chair votes aye. The motion carries.
Item number 6 is in dockets numbered 2023-38E and 2023-39E. This involves final disposition of these two dockets.
With regard to Utilities Agenda Item 6, is there a motion?
Madam Chair.
Commissioner Justin Williams.
Thank you, Madam Chair. Madam Chair, fellow commissioners, the commission received a motion to reopen the record on a limited and expedited basis filed by Dominion Energy South Carolina late yesterday afternoon on or about 3:29 p.m. Commission Regulation 103-829A provides that the parties of record have 10 days from the date of service to respond to the motion. Likewise, Dominion Energy South Carolina is allowed 5 days from service of a response to, from 5 days of service to a response to file a reply with the commission. These times may be modified by order or by order of the commission for good cause. I move that the expedited procedural schedule be as follows. Parties will have until September 22nd, 2023 at 12 p.m. to file responses to the motion. And Dominion Energy South Carolina has until September 25th, 2023 at 9 a.m. to file its reply. I also move that the commission set this matter to be reopened on September 25th, 2023 at 11 a.m. for purposes of receiving testimony limited to the issue raised in the motion filed by Dominion Energy South Carolina. The commission has, pursuant to South Carolina Code Annotated Regulation 103-803, the commission has waived its rules and regulations when compliance with such is a hardship and when waiver is not contrary to the public interest. As such, I move that the commission waive the timelines for pre-filed testimony as well as notice requirements, so long as no party to these dockets object to the waiver of any rules or regulations applicable to this matter. Finally, Madam Chair and fellow commissioners, I further move that in the event that any party to this matter objects to the procedural schedule outline, that they simply file a letter in the docket by close of business tomorrow. And if a party does object to this procedural schedule that I propose, I move that the commission reopen the record on an expedited basis. And as opposed to that schedule, we follow the normal schedule as contemplated by our regulations and hear the matter at the appropriate time. That's my motion, Madam Chair. When we go to discussion, I would like to be heard.
Thank you, Commissioner Williams. Commissioners, we've heard the motion from Commissioner Williams. Is there any discussion? Commissioner Williams is recognized.
Thank you, Madam Chair. Fellow commissioners, we know that our regulations guide our procedural schedules, and we want to make sure that we protect due process for all parties that appear before us. In this situation, it seems that some information came to light that is key to the entire case, frankly. And so, considering our schedule is very, very much so booked for the remainder of the year, I wanted to offer the parties opportunity to have this matter heard quickly so we can resolve it. But to the extent that violates their due process rights in their opinion, then we have to follow the normal course, which I appreciate and understand. The unfortunate part about that, there's no real certainty as to when we will hear the matter. And that may or may not be an issue for the parties, but I think the commission is prepared to proceed if the parties are prepared to proceed. But in the event that any party is not, then we will follow the normal procedural schedule as outlined in our regulation. And I'll be open to any questions from my fellow colleagues.
Commissioner Williams, you'll entertain a question?
Always, Madam Chair.
I reckon I'm questioning what the hearing on Monday would be. Would that just be to argue the motion, or is that to present witnesses? Is that to argue the motion, and then if the commission granted the motion, would that also move into hearing from witnesses at that time, or would possible witnesses be heard from at a later time if needed?
I'm sorry, Madam Chair, if I wasn't clear.
You may have been. I might be the obtuse one.
Well, that's okay. The motion is granted. The hearing on my motion is to grant the motion. The hearing would be to receive evidence and testimony.
Okay. Thank you for that clarification. Commissioner Carolee Williams?
Thank you, Chair Belzer. Commissioner Williams, I know there is often a part of a motion relating to a schedule where we identify that the clerk's office can work with the parties if flexibility is needed. Is that what the latter part of your motion related to?
Absolutely.
Thank you.
And Madam Chair, to the extent that I wasn't clear about granting the motion, I just want to talk. May I be heard?
Yes, sir, please.
So we all know that the core of this case is whether or not a solar generating facility. The issue's been stated many ways. It's been called the AC/DC question. It's been called the solar generating facility question as to what's 75. Is it 75 megawatts generated by the facility or put into the grid? But either way you look at it, the number is the issue. How much is the facility generating and putting onto the grid? And the accusation or the evidence that has been raised to the commissions, I shouldn't call it evidence yet, but the allegation is that there is a facility that generated over 75 megawatts AC and put onto the grid. Now, the questions about the facility: is the facility fully operational? Is the facility in testing? I mean, these are things that we received information on, but we really don't know. And there's no way to fully know unless we receive evidence about the issue. There are other questions that may come up as to whether or not it really matters to this specific case, whether or not another facility is generating more than 75 megawatts of power and putting it onto the grid. Unfortunately, we just don't know. We don't know what we don't know. And I think justice and fairness requires us to allow a party with such evidence, especially evidence that is key to a case like this, to be heard, and for other parties to respond. Again, I would like to do that sooner rather than later, but to the extent that we have to protect all parties' due process rights, and if parties feel as if the schedule is too aggressive and their rights would be violated, then we will follow the normal course, and whatever flexibility is necessary, the parties can work with the clerk on creating a schedule.
Commissioner, I don't mean to be argumentative, but I'm trying to understand. As I understand the motion is to allow parties to respond to the motion by Friday. Is that right? Friday afternoon or Friday sometime at 12. I think you said noon. And then the company would have a chance to reply on by Monday at some time. And then if no party objected, we would go into a hearing. But that response and reply goes to a motion. That doesn't go to testimony at that point. That's part of the reason I'm a bit confused. To receive a response and then a reply, that is just on the motion of whether to me, that addresses the motion to reopen. Now, I think with the motion, there was an affidavit and a purported exhibit that was filed, or whether it was an exhibit or for illustrative purposes, I'll leave that up to whoever reads it. But I don't think there was anything in your motion other than saying we would hear this on Friday afternoon that would direct the parties to be able to go forward with witnesses if need be. Did I miss that? And I don't know that I'm having problems with parties being able to have witnesses available by Monday. I'm not trying to be difficult here.
You're not being difficult at all. You're just asking questions. It puts it on the parties, Madam Chair. If they can't have witnesses here on Monday, then we won't go forward.
Okay.
What I read from the motion and the response we received from one of the parties is that what I read from the motion is that this is something that a party wants to be heard expeditiously. And to the extent that the other parties disagree with that, I respectfully request that they write a letter, put it in DMS, and we can wait the normal time period.
Okay.
But from what I read, because we're doing this for a limited basis, assuming that the record is reopened, there should not be much testimony. That's what I'm anticipating.
Okay.
Based on what has been filed thus far. Now, if that understanding is off based on your reading, I'm open to be corrected.
I'm trying to understand. We have an affidavit, and whether or not that is accompanying the motion, and to me that would be used as a basis for just the motion. But if the anticipation is that if the motion to reopen is granted, and then that we would then move into a hearing and require testimony, I don't know that affiant is available to testify. I don't know if the other parties would be able to have a response. There's also a requirement that in utility matters that for a hearing, pre-file testimony be filed. And so I'm not sure how that would impact this expedited and such an expedited schedule. I have more questions than answers. I apologize for that, but
and I don't disagree with you. My goal is to try to hear the matter sooner rather than later. Now, it's always easy just to go with what we've always normally done. If my colleagues believe that's appropriate, then that the will of the commission will rule the day. But everyone on this, everyone here knows what our schedule looks like. So what we will accept is more uncertainty about when we will hear this matter.
I understand.
And that just may be how it has to go. I'm just trying to offer an alternative.
I understand the schedule, and I appreciate you trying to. Let's move this case along. We need to go ahead and make a decision as soon as we can. So, Commissioner Carolee Williams. Well, I saw Vice Chair Powers' light on.
Yes, Madam Chair, I'm recused from this case as well.
Thank you, Vice Chair. And Commissioner Carolee Williams.
Commissioner Williams pretty well covered it, but I think his motion reopens this case for a limited issue that's been raised as of yesterday and which we received some more information on this morning. And I think he offered it to happen in a quick timeline so that we could resolve it quickly, but he also left the door open if the parties cannot do it in that time frame to work with our schedule beyond that time frame. Is that a good summary?
It is, to the extent that there are a couple of things. All parties of record have not responded to the motion, and if they are agreeable of waiving the timeline, everyone could respond to the motion on Monday in oral arguments, and we could make a decision. And then if we decide to hear the matter, we would have the hearing then. Today's Wednesday. I understand that is very vast. And if the parties can't do that, then we will follow another course of action, which I would have to rely on the clerk's office to determine what that looks like.
Madam Chair, I have a question for Commissioner Justin Williams.
Commissioner Urban is recognized.
Thank you. Commissioner Williams, I tried to listen carefully to your motion, and I don't believe that we should grant the motion to reopen the record yet. That's really inappropriate given the facts that we have. If we want to set the motion to reopen for a hearing, that's one thing, but to allow additional testimony and evidence should be in the discretion of the commission after hearing the motion. I think it's premature to rule on the motion to reopen the record since we haven't even received a reply from the petitioners in this action. I think that's premature.
Commissioner Urban, I agree with you. I misspoke. My motion is to grant oral arguments, to hear the motion, and then be prepared if we grant the motion to reopen, that we would proceed with the hearing thereafter.
Thank you, sir.
Mm-hmm. And I apologize for misstating
that's
that.
All right.
Mm-hmm.
I just wanted to make it clear that we're not granting the motion to reopen the record at this time. We're going to hear the motion at the appropriate time that you've outlined. Correct?
That's correct.
Thank you.
Commissioners, anything further on the motion?
Okay, from the non-attorney, does that mean that we will have a commission hearing on Monday morning and we will determine at that point whether to reopen the record?
If I could answer that question,
or we would have oral arguments at 11 o'clock and we would determine whether to reopen the record at that point.
As Commissioner Williams outlined, he's setting the motion for hearing, and no further action will be taken until all parties have had a chance to reply on a shortened schedule, and then we'll hear the motion at the scheduled time as to whether or not to reopen the record. We can't rule on it now because we haven't even heard a response from the petitioners. So it'd be improper to make a ruling before all parties have been heard. You understand?
Commissioner Williams, what I like about what I thought you were intending was a quick resolution of this additional information. Would you describe now what will happen? Because as I understand it, some other alternatives are available to us in this case.
Okay. So what I'm contemplating, Commissioner Williams, is this. Understanding that even setting the motion for hearing on Monday is not the normal course, considering we received the letter yesterday, I believe. I am suggesting or asking or offering, if you will, for the commissioners to consider having the motion heard on Monday. And I skipped over this part, and I'm glad Commissioner Irvin corrected me. But if no party objects, that if we decide to reopen the hearing for that limited purpose, that we be prepared to go forward on Monday as well. I mean, we spent a lot of time on this case, so my understanding that this is a very limited issue. And to the extent that my understanding is incorrect, I believe the parties will let us know that by filing. That's the intent.
Thank you.
Any further discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Justin Williams.
I vote aye.
Vice Chair Powers is recused. Commissioner Carol Lee Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
I vote no, but the motion carries.
Item number 7 appears in docket number 2023-89E. This involves final disposition of Duke Energy Progress LLC's petition for a storm securitization financing order in Phase 2 of the process.
Commissioners, we've heard the agenda item identified by Mr. Scarborough. Is there a motion?
Madam Chair,
Commissioner Justin Williams.
I move that the commission approve and adopt the comprehensive settlement agreement signed by all parties to this proceeding. So moved.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Justin Williams. Is there any discussion?
Madam Chair, I have some comments I'd like to make, and a substitute motion at the appropriate time. May I be heard?
Yes, sir.
Thank you. I have some difficulty with where we find ourselves today as a commission, and I'm going to briefly outline the reasons for that. You'll bear with me just a minute. The fact remains that under the new Securitization Act, the Commission has been given certain responsibilities required by law. And those responsibilities include, but are not limited to, designating a qualified independent third-party expert to serve on the securitization bond financing team. The proposed settlement agreement by the parties takes that away from the commission, and in fact, it gets worse. They have given that role to one of the parties, attempting to do it by settlement agreement, which, by the way, was sent to us on a take it or leave it basis. I find that offensive, first of all, because it shows that the parties don't fully appreciate or respect the commission's role in determining whether this proposal is in the best interest of ratepayers that are going to be affected for 20 years by having a separate line item of approximately $5 for every ratepayer in the Dominion Energy Progress service area. And there'll be nothing whatsoever the commission can ever do about it. Cannot revisit it under the requirements of the law. We cannot amend it. We cannot modify it. And so our role under the statutory provision was clearly important enough for the legislature to give us the authority to designate the qualified independent third-party expert. But the parties are taking that away from us, despite the clear reading of the statute. That's not fair, it's not just, and it does not protect the interest of the ratepayers that will be affected. And here's why. First of all, the whole process that we sat through was abbreviated. And what I mean by that is, because it came to us by a stipulated settlement agreement, there was no cross-examination of the witnesses. Parties all waived cross-examination. That limited our ability to learn more about the process to ensure that it protects ratepayers. And so we were left only with commissioner questions in a very abbreviated format. We were never given an opportunity to delve into the facts surrounding this so-called settlement agreement. And I'll give you some specific examples. The settlement agreement never addresses the cost that could be saved had the commission had an independent qualified expert on board. And as you know, in the past, when we designate or hire or appoint an independent qualified expert, we first put out a request for proposals. I know that's not required by law, but we do it anyway to be fair and impartial. And then if prospects make an application to serve in that capacity, we vet those experts to make sure that they are indeed independent, that they have no conflicts of interest, that they've never represented the parties in the past, nor will they do so for the future. We go through a series of questions on their qualifications, background, and experience. And as we all know, this is the first time in South Carolina that we have had an opportunity to go through the securitization process. And so it's very important that we get it right the first time, because it does set the precedent for future proceedings. And so not only do we not get to designate the qualified independent third-party expert, we don't even know who it is. We're being asked blindly to just approve whoever ends up being the expert without knowing anything about them, without knowing whether they have any conflicts of interest or who their prior clients were, without knowing if they're truly qualified. Because as we heard from the testimony of Mr. Rothschild, who has served as a qualified independent expert in several other jurisdictions, this is a complex area of the law that involves not only negotiating rates and various other issues that are going to determine how much the ratepayers will have to pay. For example, what about the cost for financing the agreement? There's not going to be any real review of those costs. The transaction costs or could impact what ratepayers will end up paying, because that goes into the deal. And so that's the first concern, is we don't really know what costs are going to be examined or questioned. The other problem is that the company has made it very clear that they're going to have the sole authority to make all decisions about how the bonds are ultimately sold. And not only that, they're not going to allow the Department of Consumer Affairs to participate in the private discussions with the underwriters. We have to take their word that all efforts have been made to make sure that the ratepayers get the least cost available. And there's no way to do that under this proposal. Duke Energy retains all decision-making authority on the bond team. And they could have proposed a more collaborative process. That's what I was hoping for. A process that would give us and recognize our role as commissioners to designate a qualified independent expert that we find qualified, fair, and impartial to participate in this process. But they've chosen to take that away from us. But it gets worse. What they have really attempted to do, they've never fully acknowledged the commission's role in this proceeding. They've refused to allow the commission to impose any condition not inconsistent with the law. That's part of the statutory provision. We have the right to impose conditions to the financing order that fully protect ratepayers. No, they've taken that away. Instead, Duke has sent us a take it or leave it proposal that falls short of the statutory mandates required in this securitization docket. What they did is they presented limited testimony under their stipulated agreement, waived cross-examination of the witnesses, leaving commissioners with the sole task of asking difficult questions, resulting in a proceeding that was shortened and interrupted by repeated objections to commissioner questions. I find that shocking, really, because not only do they not want us to have any input, they don't even want us to question them. They don't want us to question the witnesses. So what are they hiding? What are they hiding from the commission and ratepayers in this instance? The whole thing is very troubling when you consider what our role as commissioners is. And of course, they said, well, you'll get a chance to see the financing order and you'll get a chance to see the certifications by the underwriter and the qualified independent expert, whoever that turns out to be. And we'll get to see them, but we won't get to alter them or change them, because guess what? The parties are going to write the proposed order. They're going to impose on us their order. And it's too late in the process once we get to the next round to have any input, because you know what's going to happen. The company's going to say, well, if you all turn this down, we'll never be able to go back and seek securitization bonds again. It's going to be a black mark on the company. Well, that's not true. Each deal stands and falls on its own merits. So, you know, we found ourselves in a very difficult position here today. And I would encourage you to think carefully about what should the commission's role be in this process? Have we been provided proper consideration under the law, as required by law, to fully participate and review in this process, rather than take this so-called take it or leave it deal? I find that offensive. And by the way, when the ratepayers get those bills for 20 years, they're going to have some questions about it too. Like, what does it pay for? What costs were rolled into that number that requires us to make monthly payments for 20 years? And is there any way we can appeal it? Well, the answer is no, you can't appeal it. It's final. And what it does, it allows you to shift their securitization liabilities directly to ratepayers. And there'll never be any opportunity to go back and change that. So we have to be sure, for example, that if we wanted a 7% cap, why is it not provided for in the settlement agreement? In fact, they've already told us they may seek a variable rate of interest. Well, how is that going to affect ratepayers if interest rates change? We don't even know. We have no idea. What about the fact that we have not been given an opportunity to talk about the floating rate bond issuance? That really concerns me. Will the qualified independent third party be truly qualified? We don't know. What does the public interest mean for ORS? ORS, you know, I'm sure will do a good job. They will certainly likely find that there are quantifiable benefits to ratepayers. But what about all these other issues that will never be reviewed? What about the sale itself, the means of sale? The parties have turned the lowest cost charges to be the standard, but the statutory cost objectives are different. Um, there are risks that they may go forward and not do an SEC registered sale. What
Madam
about the
Chair.
carrying cost on the regulatory asset at DEP's approved pre-tax weighted average cost of capital? When the
Commissioner
financing
Irvin?
is structured, yes, ma'am.
Commissioner Caston has a question if you're willing.
Yeah, I will as soon as I complete my remarks.
Okay, thank you.
How does a 144A sale lead to the lowest cost for ratepayers? Isn't that going to be marketed to a smaller group of investors? Whereas if it were marketed to a larger group of investors, would it make it more marketable? Would it reduce the cost of the transaction? These are all questions that we never got answers to. So I think it's premature to grant this motion, particularly when we don't even know, we still don't know who's the qualified independent third-party expert. That is most concerning. We still don't know. And who's to say when we'll know? It's going to be too late in the process. We'll never be able to have an opportunity to question that independent, so-called independent third-party expert. We'll never be able to ask about their qualifications, background, and experience. And you heard Mr. Rothschild testify under oath that based on his experience with securitization proceedings, he learned something new every day. And I asked him, do you think a state agency attorney is qualified to serve in that role? And he said, no. So we have testimony before us that clearly indicates that we're going down the wrong path. And for all those reasons, I would like to hear from Commissioner Caston. If he has a question, I'll be happy to answer.
Thank you, Commissioner Irvin. Commissioner Caston?
I have no question. I was just ready to
Okay.
vote.
Commissioners, any further discussion? I think Commissioner Irvin indicated he had a substitute motion.
Yes, ma'am, I do. Given the fact that we've not been allowed to perform our mandatory statutory review of this process, given the fact that we were given a take it or leave it deal, it was negotiated outside our presence, that we're not had a chance to ask questions about the terms of the financing, the impact that will have on ratepayers. I move that we reject the proposed settlement agreement and ask the parties to go back and continue their negotiations and come up with a better agreement that complies with the statutory requirements of law. So moved.
Thank you, Commissioner Irvin. Commissioners, we've heard a substitute motion offered on this agenda item. Is there any discussion? Commissioner, I listened very carefully during this hearing, and I heard some of your concerns I heard addressed during the proceeding, and I felt comfortable with the responses that were given.
Do you have any concern about not?
May I finish, please? I was talking.
Sorry. I
Thank you.
apologize.
I now lost my train of thought. No, I don't have any concern about the qualified independent third party. The qualified independent third party, we know who that is proposed to be by the settlement agreement. and that is the Office of Regulatory Staff. And I specifically asked the ORS witness, Mr. Roden, if ORS would be hiring a consultant, and I believe he responded in the affirmative. Now, I may not know who that consultant is, but I know that ORS has the duty to represent the public interest. I also know when you referenced Mr. Rothschild's testimony that he was a witness for the Department of Consumer Affairs, and the Department of Consumer Affairs was a signatory to the settlement agreement, and the Department of Consumer Affairs represents the interest of the ratepayers in South Carolina. So I believe that they gave their assurance that they are comfortable with the settlement agreement as well. You had a lot of points, and I disagreed with a lot of them, and I can't recite all of them, but I don't agree also that with the characterization of, or description, let's say, of an abbreviated proceeding. Granted, the parties they agreed to waive cross-examination, but that did not limit the commissioners from asking any questions that we wanted to. And as chair, I did not limit any commissioner from asking whatever questions that any commissioner wanted to ask. So I know we have a very tight hearing schedule, but we finished on Thursday before lunch. We had a commission meeting that afternoon. We were prepared to come back in on that Thursday afternoon and then continue into this. Was that just last week? It has been such a long couple of weeks. We were prepared to come back in on Monday of this week if needed and continue as we continue until we finished. And so I take exception to any inference that anyone was rushed, that anyone was precluded from asking questions, that any questions that needed to be asked and answered by commissioners with concerns or issues or questions that anyone was limited in the questions that they could have asked. So that's just I just take exception to that and want that to note that. But while I appreciate your point of view, I respectfully disagree with it, and I will not be supporting the substitute motion. Thank you, Commissioner. Any further discussion?
Madam Chair.
Commissioner Justin Williams.
Commissioner Urban, I appreciate your concern, and I think it's good to have that level of concern considering how and when you and I came to the commission. As you point out, if securitization passes, there's going to be an itemization on ratepayers' bill for a significant amount of time. And considering the number of public hearings that we've all attended, I seriously doubt that anyone is going to thank us for that, regardless of how much money it may save, because it's going to be an itemization on their bill for something that they've never seen before. But even in the face of that, we know through the stipulated testimony and the other testimony that was put on record last week that there is a potential for quantifiable net benefits for customers, savings. One figure quoted was $41 million. And regardless of what ratepayers may think about securitization, I'm comfortable with what was offered and proved at the hearing, even in the face of some of the same concerns that you have. I'm comfortable with the testimony provided by the company that said that everyone that's on the bond team will have equal and fair voice, that they will have opportunity to communicate their concerns to the commission and the DMS, that they have to communicate those concerns in the report that's filed by the company, not to mention the certification that will be filed by the qualified independent third party, in addition to any other comments or any other issues that they believe are appropriate. I'm not going to relitigate the case, but I will tell you that the same concerns that you have now, I had before, but that thorough process leaves me convinced that this is the right way to go based on the evidence of record. Now, that doesn't mean anything other than that's just the way I feel, and reasonable minds can differ, and I respect what you're bringing to our attention. I just think the record speaks for itself, and it supports that we should adopt the stipulation. And I'm not sure that the commission, or I'm not convinced that the commission going through their RFP process to select a qualified independent third party will create a better result in this process. I think the Office of Regulatory Staff is more than capable, and I think they will do a fine job as QITP with the support of an expert. And I'll just say this in closing. I know that, you know, you and I came in at a time where tensions were high and utilities were not highly thought of, but I will say that the whole concept of securitization is one that benefits both the utility and the ratepayer based on the quantifiable net benefits. And as Mr. Cooper said in his closing argument, the reason that we're even having this hearing is because the company moved forward with trying to advocate for savings through the General Assembly to even create the securitization statute. And while there have been questions to their intent and questions about whether or not they will work to get the lowest possible cost to ratepayers, I think the testimony and evidence that they offered, along with the agreement from all parties, including the consumer advocate who represents the consumer, household ratepayer, along with the Office of Regulatory Staff that represents the public interest, along with Nucor, which is a very important South Carolina business, for some reason or another, they all seem to think that this is the right course of action. And for me, it's hard to see, based on the evidence and evidence presented in the hearing and the affirmations or answers to questions given by the attorneys, it's hard for me to see stepping in front of that, absent some high-level concern. And I understand you have your concerns, and I respect them, but through the hearing, the parties have addressed my concerns. And for that reason, I respectfully will not be supporting your motion.
Thank you, Commissioner Williams.
Commissioners, any further discussion on the substitute motion? Commissioner Caston?
Just, I had many concerns through the course of this. It's been a very challenging case. That said, I applaud Commissioner Irvin's passion and detail. Been there. But during the hearing, I do feel like the questions that I wanted to ask were asked. And those I didn't ask because someone else asked them, and I didn't feel the need to ask the same question. I feel comfortable with the process. And respectfully, Commissioner Irvin, I'll not be able to support the motion either.
Commissioners, anything further?
I'd ask for a roll call vote, Madam Chair.
Yes, sir. Of course. We have the substitute motion by Commissioner Irvin I will succinctly say, reject the settlement agreement. Is that sufficient, Judge Irvin?
Yes.
Okay. And we will proceed to a roll call vote, starting with Commissioner Irvin.
Aye.
Commissioner Thomas?
No.
Commissioner Justin Williams?
No.
Vice Chair Powers?
No.
Commissioner Carol Lee Williams?
No.
Commissioner Caston?
No.
And I vote no. The substitute motion having failed, we will proceed to the original motion.
Chair Belser,
Commissioner Carol Lee Williams.
I have a substitute motion to offer.
All right, we have another substitute motion. Commissioner Carol Lee Williams is recognized.
I move that the Commission approve and adopt the comprehensive settlement agreement signed by all parties to this proceeding with one request. I move that the parties consider ORS serve as the procurer of the qualified independent third party or the QTP consultant and give the PSC advice and consent over the selection of the QITP consultant. I move that ORS provide the identity of the consultant retained to perform the duties of the QITP consultant to the Commission by October the 3rd, 2023, so that the Commission can approve the QITP consultant before issuing of the financing order deadline pursuant to South Carolina Code Annotated Section 58-27-11110C6A. The QITP consultant and ORS will allow the Commission to certify whether the sale of storm recovery bonds complies with the requirements of the article, including the duty to certify lowest cost charges on behalf of the ratepayers, as well as compliance with the terms of the financing order. If the parties cannot agree to this request, please inform the Commission within 4 working days. I so move, and I have some comments, Chair Belser.
Thank you, Commissioner Williams. Commissioners, we've heard the motion the substitute motion offered by Commissioner Carolee Williams. We'll now take comments, beginning with Commissioner Carolee Williams.
Thank you, Chair Belser. I want to tell you what one judge sees through this securitization process, because as many of you have said, it's a complicated circumstance that we find ourselves in. I see that the parties have produced a settlement agreement that is good. It works together to devise a system for determining securitization costs that will save customers money and be fair to the company. The settlement agreement was put together for the best interest of the parties that formulated it as understood at the time. This motion just offers one suggested adjustment to this amendment. And I recognize that in all settlement amendments, there are compromises that were made, and not every party got all that they were asking for. But as we heard in testimony, particularly the Department of Consumer Affairs and ORS witnesses both testified that their concerns were addressed in the settlement testimony. But I also see a settlement that identifies ORS as the QITP. This settlement does not identify who or even if the ORS will have a consultant. They did identify in testimony that there would be a consultant, but it's not identified in the settlement agreement. This causes me, despite the goodness of the settlement agreement, to have concerns that the process will not result in the confidence I need that the customer is getting the lowest storm recovery charges consistent with market conditions at the time the storm recovery bonds are priced and the terms are set forth in such financing order as required by law. 27-1110-6CA says the independent third party designated by the Commission shall review the issuance advice letter and deliver its independent certification to the Commission. And I'll quit reading that section in the interest of time. This is this Commission's first opportunity to fulfill the General Assembly's intention. Were there more of a record regarding the best practices of securitization as fulfilled in South Carolina, I might have come to a different conclusion. I prefer to see an outcome that is closer to what I believe was the General Assembly's intent. I am comfortable with ORS selecting the QITP with the Commission's advice and consent, where the Commission is assured that the QITP can confidently provide unqualified certification that the outcome is producing the lowest storm recovery charges consistent with the market conditions at the time. ORS and the Department of Consumer Affairs and the Public Service Commission are all smart, good-hearted, hardworking state employees working for citizens and businesses of South Carolina, and we want the best outcome for the using and consuming public. We have never done this, entered into a securitization process before, and the settlement agreement has us agreeing to allow ORS to select their own consultant without any oversight on our part. For these reasons, I'm uncomfortable with the settlement agreement as proposed. In my opinion, it jeopardizes our ability to fulfill the state statute as well as our confidence to offer savings to consumers that is the lowest cost possible. Hence, the substitute motion. Thank you.
Thank you, Commissioner Williams.
Madam Chair.
Commissioner Thomas?
Thank you. I would just start off by saying I very much appreciate Commissioner Carol Lee Williams' substitute motion. She raises many of the same concerns that I have, and I will be supporting her motion. But I would like to say that the QITP is very important, and the person that ends up being hired by ORS as the consultant is very important. It's a very complicated area, and it needs to be a highly qualified independent consultant. And I believe that Commissioner Carol Lee Williams' motion does at least give us some say in who that may be. And I believe that's very important. A couple of other points that I'd like to make is there's been mention of Department of Consumer Affairs and their role on the bond team. And I understand that they're okay with their role. But a concern that I have is that their consultant should be involved, and that is not addressed in the settlement agreement at all. Their consultant is not named as being part of the advisory group. I think that person should be. I think that's extra input, good input. That's a concern, which again, at least makes me feel like Commissioner Carol Lee Williams' motion is a step in the right direction. And additionally, in my opinion, the importance of the unqualified opinions cannot be overemphasized. That was not addressed in the settlement agreement either. I think that's extremely important. I hope that the parties will take note of that and take that very seriously. Beyond that, I think I'll just sum it up by saying I will be supporting the Commissioner Carol Lee Williams substitute motion. Thank you.
Thank you, Commissioner Thomas. Commissioners, further discuss. Commissioner Justin Williams, your light is on.
Yes, ma'am. Thank you, Madam Chair. Commissioner Williams, Commissioner Thomas, I'm very happy about the even though we're I don't even know which motion we're on at this point, but the good news is we are spending the appropriate amount of time, not only in the hearing room, but outside of the hearing room, going through the issues that are facing us here. And each of us have our own way of getting to our vote. And so I'm thankful that the concerns are being raised and we are discussing them. Out of respect for you, Commissioner Williams, I just want to make sure that you understand why I will not be supporting your motion. I think the way I see my role as a commissioner is to determine whether or not if it's a stipulation, whether the stipulation we receive meets the burden for approval. In this case, we're talking about a stipulation, and I believe that's the case, which is why I made that initial motion. That doesn't necessarily mean, at least to me, that everything in the stipulation is being done the way that I would do it if I was in charge. I see my role as a commissioner as not necessarily being in charge of the decision making, but deciding whether the decisions are made are sometimes reasonable and prudent, but in this case will lead to the lowest cost to ratepayers at the time of issuance. And I think that's an important phrase of art, lowest cost. From what I picked up through the testimony, there's really no real certain way to the cent to know whether you're getting to that statutory requirement. other than the process that's put in place to ensure that whoever is making the decisions are doing so in a way that industry standards support would lead to that lowest cost. And I think that while the statute empowers the commission to designate a QITP if we require issuance and advice letter in the financing order, it does not restrict how that is done. And to the extent that what was offered in the stipulation supports ORS serving as QITP, if we adopted the stipulation, that would be our designation. Outside of that, I think we would be rejecting the settlement or rejecting the stipulation, which is the motion that Commissioner Irvin made, and ultimately that motion failed. Your motion is a creative way to try to create a collaborative effort. I'm not sure that is that level of collaboration, or I don't believe that level of collaboration was anticipated by the statute. And to that end, I would like to ask a question if you're open for a question.
Commissioner Carol Lee Williams, will you entertain a question?
I will entertain a question, but I think that this discussion and the motions that we put out there are probably what is most helpful to the process. Okay. You know, just to have more feedback than just the initial motion.
Okay. Oh, you mean my motion at one sentence?
Yes.
I got you. I was always taught less and more, but I understand what you're saying.
We made up for it today.
Let's say I were to support your motion. How would that process, how do you envision that process working in terms of ORS selecting or identifying a QITP, and then we would give with our advice and consent? So would they bring folks before us? What would that look like?
Part of this is for them to come back to us, because the parties would have to agree to this the way my motion reads. It doesn't specify any more than that, and I wouldn't specify. I think that one alternative is to, a letter from ORS that said we went through a process, and this is who we've selected, and these are the numbers of securitization cases that they have taken to other commissions. This is why we support this recommendation and ask for your consent and approval. I think that one of the benefits of my motion is that it means that as ORS selects the unknown consultant, they have to be thinking in advance about our approval, knowing that we all want this securitization process to work successfully for all parties involved. So I'm not going to talk through specifics, because I don't think that's my role, and I give the parties that flexibility. I recognize that they produce this over a couple of day time period, and I'm not going to in a couple of minutes come up, nor do I think it's my role to identify how that would actually work. But I think a letter with the qualifications attached, and particularly knowing that the team involved has no conflict of interest. I'm getting my juices going now. So no conflict of interest.
Oh, so they will let me have it. I got it.
The number of securitization processes that they have served as something like a QITP for would also be helpful.
Okay. I think that's fair. I think that's more than fair. My concern is I like to sort of anticipate what's coming next. sort of look over the horizon. If they do all of that and it doesn't meet the commission's approval, what would happen next? Would they have to go, I guess, select someone else and write the letter, and we would go through that process until we approve? Just in case the first iteration is unsuccessful.
I think that's something for the parties to think through, and I think that's also something for us to weigh as we, I hope, and it's just a hope, that we would get a team presented to us that has no conflict of interest, that has qualifications that impress us, and that we say yes. And that's really my goal in recommending that the parties consider this, is to get to yes and to get to a level of confidence all the way around. We won't be in the room, and this is, to me, the closest we can get to that confidence that I am looking for.
Understood. Thank you,
Madam
ma'am.
Chair,
Just a sec, Commissioner Williams, Justin Williams, are you concluded?
Just one last comment, or it's not necessarily a question, or it could be a question. Understanding what you just shared with us, Commissioner Williams, and how that works, I get it. The only concern I would have is considering ORS is a separate agency and doesn't report to the commission, and the commission doesn't have authority over the office. I'm wondering whether or not we, by issuing an order, is it requesting them to send us that letter or requiring them? What is the mechanics of that?
What I'm asking is for them to consider allowing us to offer advice and consent over their selected expert. And I'm asking them within a short amount of time to tell us if that would be appropriate. And then we make our decision on securitization after that information is provided.
Oh, so
that's not true. No, that's not true. My motion is to approve the settlement agreement with one request that asks for additional information.
Okay, so just a letter, informational, for your information, we're selecting.
No, I think I'm talking about the process that I'm saying we are approving the comprehensive settlement agreement with one request, and I'm asking them about the process of identifying who the QITP is to us for advice and consent. I want to know if process-wise, I want to know if within 4 days, so we would know by next week whether they would offer that to us. Also, as part of this, I asked that they let us know by October 4th, which is not that many days longer, who the QITP is, so that we know and have that confidence by the time that we issue the financing order.
Okay, I got it. So, but when you frame it as requests, so your motion is to approve the settlement of the stipulation, period, then request that information from the Office of Regulatory Staff, period, and then some timelines. If they respectfully refuse to answer your question, that has no bearing on adopting the stipulation, correct?
Correct.
Okay.
I am respecting the fact that they gave us a settlement agreement that was entered into by all parties and compromises were made and at the time was the best product they could give us. I'm asking them to consider this one addition in the time frame that I've suggested to enhance our confidence and to, I believe, bring us more in line with the statute that allows us to designate the qualified independent third party.
Okay, thank you, ma'am.
Commissioner Thomas?
thank you. I appreciate that. And basically, I think that that last conversation there between the Williams twins was productive and basically brought out the points that I was going to bring out. So at this point, I don't have an additional comment. Thank you.
Thank you, Commissioner Thomas. Commissioner Carly Williams, I have some questions if you don't mind.
I don't mind.
I just want to be clear. I understood originally, and I may have written, my notes may be incorrect, but that you indicated that ORS selecting the QITP with commission advice and consent. Is that correct?
The QITP consultant.
Okay, the consultant, because I mean this
ORS
is not
is the-
changing
right.
ORS from the QITP.
Thank you for
the
clarifying
recommendation in the settlement agreement that they be the QITP.
Right.
Okay.
I mean, that is, I agree. That is,
Okay.
This continues the idea that ORS would be the QITP, but it also respects the fact that securitization is something absolutely new to all of us. And
Well, how does advice and consent work? I mean, they send us a letter. We can't conduct an independent investigation of who that consultant, of a named,
Right.
a possible
Right.
named consultant. I'm just curious as to you would request that information about the number of securitizations and whether conflicts checked had been done. And I just am curious as to how the advice and consent part works.
And I don't know if the
Okay.
commission has a definition for that. In my mind, we were looking for getting the information in terms of who that expert would be in order to help us finalize the financing order, which means we've got to know by the financing order deadline, which is October 13th. My motion asked to know.
I think it was
who that-
October 4th. wasn't it?
October 3rd.
3rd.
So that, and what this is not in the motion, but that gives us enough time to put it on an agenda that the week of the 3rd or even the following week, and to approve or not the qualified independent third-party consultant.
And what would
Madam Chair, when you finish, I've got a question or two for Ms. Williams as well. Thank you.
Thank you, Commissioner. And what if the commission did not approve the
Right.
consultant?
I said this 20 minutes ago. I think the goal of this motion.
I'm sorry to be repetitive.
No. It really was to have this discussion. I don't have it all worked out, and I'm not going to pretend to have it all worked out.
Okay.
But
I appreciate your forthrightness. I really do. Okay. I'm fine with that if you are.
Yeah.
All right. Commissioner Irvin?
Thank you, Madam Chair. Commissioner Carly Williams, I've got a couple follow-up questions. I really liked the sound of your motion when you began. It sounded to me like you were going to require the Office of Regulatory Staff to recommend a qualified independent third-party expert to the commission for its approval, which is consistent with the law and the statute on securitization, because we must designate. Nobody can do that other than the commission, in my view, under the law. And so I'd like to support the concept, but a letter alone is not sufficient. We have the right and the responsibility to have that person or persons come before us under oath to answer questions, just like we always do when an expert is selected in one of our dockets. And a letter can't be cross-examined or questioned. I want to know who their qualified third-party independent expert is, and I want them to appear and answer commission questions so that we can truly satisfy ourselves that they are in fact qualified and that they are in fact independent of the parties involved in this docket, and that they understand their role. And so I can't support your motion unless it requires that ORS not only tell us who their independent qualified expert is, but that person has to appear before the commission and answer our questions under oath on the record so that we can then designate them if we think they are in fact qualified and independent. So if I'll have to regretfully vote against a letter, I want the person identified. I want them before us so that we can do our statutory duty to assure that they are independent and qualified. Thank you.
Madam Chair.
Thank you, Commissioner Irvin. Commissioner Thomas, Commissioner Caston's had his light on for a little while. May I come back?
Sure.
Thank you. Commissioner Caston?
Thank you, Madam Chair, and don't want to prolong this, but it's certainly more comfortable to be in one accord than not. Disagreements, differences, opinions, inevitable. And one thing I can say, I've been on the short end of the stick on that on more than one occasion. And I can say this, that I'm still honored and proud to serve with this group, because when I was on the short end of the stick, these commissioners have always been cordial, respectful, even in our disagreements. That said, I don't make a decision, yes or no, unless I just feel comfortable that this is where I am. This is the right thing to do. And sometimes it's a challenge when there's that little gray area here or there. As much as I appreciate the desire, and I know, I feel confident in your desire. It is for good, noble purposes and reasons. I can only speak for me, but enough of my concerns, if not all, were answered in the hearing. So, with great respect, I'm not going to support this, but thank you.
Thank you.
Excuse me.
Go ahead.
Commissioner Thomas?
Yes, I would just like to say that to me, it would be very important and worthwhile to see the process that ORS goes through to pick this consultant. What's that process? Bring that to us. And what are the qualifications? Bring that to us. I just think it's important, and I will be supporting the motion. Thank you.
Thank you, Commissioner Thomas. Commissioners, anything further on Commissioner Carolee Williams' substitute motion? Hearing nothing further, we will proceed to a roll call vote. This is on the substitute motion. Commissioner Carolee Williams?
Aye.
Commissioner Caston?
Respectfully, no.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Commissioner Justin Williams?
Respectfully, Commissioner Williams, I vote no.
Vice Chair Powers?
No.
And the chair votes no as well. The substitute motion fails. We now return to the original motion. Commissioner Irvin?
Yes, ma'am. I'd like to address Commissioner Haddon Thomas just for a moment. I thought you had some excellent suggestions earlier in your comments, but they were not put in the form of a motion. And wondering, before we get to the final proposal, that would you like to place those very good suggestions in the form of a motion so that we can consider them.
Thank you. I appreciate that. No, I'm not really going to do that. I think, like some other people have said today, part of the importance of what we're going through now is making it very, very clear what we expect and what we want to the parties. And I think that we're doing a good job of that. And I'm satisfied with where we are at this point. But I appreciate that.
Commissioner Irvin, are you through?
Thank you for your consideration. That was my only question. Thank you, Madam Chair.
Thank you, Commissioner Irvin. We now return to the original motion offered by Commissioner Justin Williams and to approve the settlement agreement. Any further discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Justin Williams.
Aye.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams.
I abstain.
Commissioner Caston.
Aye.
Commissioner Irvin.
No?
Commissioner Thomas.
Aye.
The chair votes aye. The motion carries.
Item number 8 is in docket number 2023-211WS. On September 18th, 2023, the Commission received a letter from the Office of Regulatory Staff requesting that this item be carried over to allow ORS the opportunity to complete its review. Therefore, staff recommends that this item be carried over.
Item number 8 is carried over.
Thank you. Item number 9 is in dockets numbered 2016-348S, 2017-28S, and 2021-130S. This is a request for release of a collateral assignment form filed on behalf of Bright House Financial.
With regard to utilities agenda, item 9 is identified by Mr. Scarborough. Do I hear a motion? Commissioner Caston.
Thank you, Madam Chair. I move that the Commission direct the Executive Director and Chief Clerk of the Commission to execute the release of assignment form required for Bright House Financial to release the assignment on the life insurance policy of Keith Parnell.
Commissioners, we've heard the motion of Commissioner Caston. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Justin Williams.
Aye.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams.
Aye.
And I vote aye. The motion carries.
Item number 10 appears in docket number ND-2023-25A. This item involves the Office of Regulatory Staff's comments and recommendations in this docket.
With regard to utilities agenda item 10, is there a motion?
Madam Chair,
Commissioner Thomas is recognized.
I move that the Commission open a new administrative docket requesting the electrical utilities subject to the Commission's jurisdiction provide semi-annual reports related to the Federal Inflation Reduction Act, or IRA, which will be consolidated with docket number 2022-168A for administrative purposes. The utilities shall provide information related to their efforts to obtain directly or indirectly federal grants or other benefits under the IRA. A quantification of net benefits expect to flow to ratepayers as a result of those programs, information related to any regulatory obstacles that may prevent the utilities from receiving benefits under the IRA, and any other information the utilities deem relevant and compliant with this directive. Accordingly, the utilities may file a consolidated report on information related to both the Infrastructure Investment and Jobs Act, the IIJA, and the IRA. I further move that the report is due July 31st of each year, covering January 1st through June 30th review period. and a report due on January 31st of each year, covering a July 1st through December 31st review period. I further move that the initial report will be due January 31st, 2024. So moved.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Thomas. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Thomas.
Aye.
Commissioner Justin Williams.
Aye.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
I vote aye. The motion carries.
Item number 11 appears in docket number 2019-233A, which involves Duke Energy Progress LLC's and Duke Energy Carolinas LLC's annual reports filed on April 28, 2023, and the substance of prospective reports filed pursuant to Commission Order number 2023-38.
With regard to utilities, agenda item 11 is identified by Mr. Scarborough. Is there a motion?
Madam Chair.
Commissioner Caston.
By order number 2023-38, dated January 18th, 2023, the Commission addressed procedures for treatment of deferrals, which may be requested by utilities subject to the Commission's jurisdiction. And by order number 2023-38, the Commission issued guidelines related to treatment of accounting deferrals. One of the guidelines established in order number 2023-38 was the requirement for all utilities which have received a deferral accounting order to file an annual report. Order number 2023-38 requires the annual report to detail each deferral accounting order that is outstanding and to include the subject matter of the deferral, description, balance, carrying cost, current duration, impact on rates, and the estimated date to begin amortization. The Commission now seeks to clarify the requirements of the annual report required by Order number 2023-38 to provide further specificity and guidance to Commission proposes to and guidance to what the Commission expects in the annual report. To that end, the Commission proposes the following language to clarify that the annual reports shall provide all the requested information for all deferrals to include any deferrals which have not been placed into rates and also any deferrals which have been placed into rates from a prior proceeding but have not yet been fully amortized. Shall include any and all deferrals that have been fully amortized subsequent to the prior annual report. In other words, the report shall include any deferral which has been fully recovered during the period between two annual reports, and shall provide the dollar value impact on the revenue requirements for deferrals placed into rates and are currently being amortized, and for deferrals which have been fully amortized but have not yet been removed from the revenue requirement. Pursuant to South Carolina Code annotated sections 58.5.320, 58.9.1180, and 58.27.2130, I move that this directive be served on all regulated electric, gas, water, and wastewater utilities in South Carolina to provide notice of this clarification, which could lead to an amended order being issued. Utilities shall be allowed 30 days to provide comment on the clarification as set forth herein. I so move.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Caston. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Justin Williams.
Aye.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams.
I vote aye.
And I vote aye. The motion carries.
Item number 12 appears in docket number 2023-56C. This is a request from Cogent Communications Holding Incorporated to close this docket.
With regard to utilities, agenda item 13, is there a motion?
And
Vice
that's
Chair
number
Powers?
12, Madam Chair.
I'm sorry, number 12.
I move the Commission grant the request of Cogent Communications Holdings Incorporated that this docket be closed. I further move that the Commission accept for information only the notice that Cogent has filed a discontinuance application with the Federal Communications Commission related to the provision of session in initiation protocol trunking service to enterprise customers across the United States. So moved.
Thank you, Vice Chair. Commissioners, we've heard the motion from Vice Chair Powers. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Vice Chair Powers.
Vote aye.
Commissioner Carolee Williams,
Aye.
Commissioner Caston,
Aye.
Commissioner Urban,
Aye.
Commissioner Thomas,
Aye.
Commissioner Justin Williams,
Aye.
and I vote aye. The motion carries.
Item number 13 is in docket number 2023-70G, which involves final disposition of this docket.
With regard to Utilities Agenda Item 13, is there a motion?
Chair Belzer, I'd like to make a motion.
Commissioner Carolee Williams is recognized.
Thank you. I move that the Commission approve the amended stipulation between Dominion Energy South Carolina, Inc., the Office of Regulatory Staff, the Department of Consumer Affairs, CMC Steel, South Carolina, IGS Energy, and Direct Energy Business Marketing, LLC. I'm sorry. I am confused. Thank you. The amended stipulation with amended attachments A and B provide for the correction of a mathematical error reflecting the company's overall decrease to margin revenue of $5,127,991, or approximately 2.07% below current rates. The company's overall revenue requirement increase of $8,872,986, and which is a decrease of approximately $10,584,730 relative to the application filed by Dominion Energy South Carolina with the Commission on March 31st, 2023. The Commission finds that the amended stipulation is in the public interest due to the decrease in rates from those originally requested from the 5.6% increase to a 2.2% increase with no change to the base facility charge. The Commission finds compelling that the amended stipulation includes customer benefits such as the commitment to study the rates of reimbursement and calculations associated with the Rate Stabilization Act and Weather Normalization Adjustment. Another example of the benefit to customers is that within a year, Dominion Energy South Carolina will study its natural gas pipeline capacity to ensure its natural gas distribution system has sufficient capacity to reliably serve peak day, peak season, and annual requirements of all customers at the lowest reasonable cost, consistent with short and long-term reliability and safety requirements, while simultaneously accommodating anticipated system growth. I further move that the Commission approve the updated transportation pool agreement and gas general terms and conditions, and that they be made exhibits to the final order. I so move.
Commissioner Williams, that's your motion?
Yes.
Would you accept what I would consider a friendly amendment? If you don't consider it friendly, I'll make it as an amendment, regular amendment. But we have just over a week to get the order out.
Yes.
And
I can read your mind.
South Carolina Code Annotated Section 58-5-240D, I believe it is, allows the Commission to grant an extra 5 days if the Commission determines that it can't get the order out reasonably within our control. So would you accept as a friendly amendment to grant the extra 5 days allowed by statute?
Absolutely.
To get the order out? And I would just note that I know staff is working and preparing, and our hope is to get it out without need of the 5 days, but I think that we need to go ahead out of an abundance of caution and grant that extra 5 days. If so, if you'll accept that as a friendly amendment, I'd appreciate it. So, thank you. Commissioners, we've heard the motion from Commissioner Carolee Williams with the friendly amendment, or so we'll say as amended. Is there any discussion? Hearing none, we'll proceed to a roll call vote on the motion as containing the friendly amendment and start with Commissioner Carolee Williams.
Aye. And I believe that Vice Chair Powers indicated earlier that he was recused on this one.
That's correct.
Okay.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Justin Williams.
Aye.
As indicated, Vice Chair Powers is recused, and the chair votes aye. The motion carries.
Item number 14 appears in docket number 2023-312E. This is the joint application of Duke Energy Carolinas LLC and Duke Energy Progress LLC for authority to transfer intercompany assets, for approval of accounting authority related to the transfer, and for expedited approval of both matters.
Item number 14, as identified by Mr. Scarborough, is in need of a motion. Do I hear a motion?
Madam Chair,
Commissioner Irvin is recognized.
I move that the commission approve on an expedited basis without notice or hearing the requested intercompany transfer between Duke Energy Carolinas and Duke Energy Progress of the rotatable spare assets, along with the requested accounting treatment, subject to review by the Office of Regulatory Staff. So moved.
Thank you, Commissioner Irvin. Commissioners, are there any questions on the motion? Commissioner, would you entertain a question?
Yes, ma'am.
I believe that, now I think your motion covers this. I just want to make sure the Office of Regulatory Staff filed a letter indicating that they and Duke did not, ORS didn't, but this is not their wording, this is my wording, didn't object to Duke going ahead with the work that needs to be done, subject to review and true up if need be. Is that your understanding, and is that the understanding of your motion as well?
Yes, and I will include that as part of the motion. I believe that
So basically,
that is appropriate.
it would just be authorizing Duke to proceed with the intercompany transfer of assets as necessary, and afterwards the ORS would conduct its discovery and review and subject to any true up or
Yes,
okay.
I accept that as a friendly amendment. Thank you.
Thank you, Commissioner. Commissioners, you've heard the discussion that resulted in a friendly amendment. If you need clarification, I might be hard pressed to do that, but is there any further discussion or any clarification needed? All right. Thank you very much. Commissioners, let's proceed to a roll call vote, starting with Commissioner Irvin.
Aye.
Commissioner Thomas?
Aye.
Commissioner Justin Williams?
Aye.
Vice Chair Powers?
Aye.
Commissioner Carolee Williams?
Aye.
Commissioner Caston?
Aye.
And I vote aye. The motion carries.
Item number 15 is in docket number 2023-154E. This is a joint motion for protective order filed by the South Carolina Public Service Authority, the South Carolina Coastal Conservation League, and the Southern Alliance for Clean Energy.
With regard to utilities, agenda item 15, do I hear a motion?
Madam Chair,
Commissioner Thomas is recognized.
thank you. I move that the commission approve joint motion of the South Carolina Public Service Authority, Santee Cooper, and South Carolina Coastal Conservation League, CCL, and the Southern Alliance for Clean Energy, SACE or SACE, for a protective order. The protective order, as requested by the parties, shall: 1. Protect from discovery by certain interveners information sought and request 2-1 of CCL SACE second set of data requests, which was attached as Exhibit A to the joint motion and served upon Santee Cooper by CCL SACE on July 21st, 2023. And 2, told the deadline for Santee Cooper to respond to request 2-1. Santee Cooper asserts that the information sought by CCL SACE contains market-sensitive data that, if disclosed to market participants, may irreparably harm the gas shippers, and that such information deserves heightened protection in this proceeding. The disclosure of the information sought in connection with request 2-1 shall be provided only to CCL SACE and to the South Carolina Office of Regulatory Staff, as agreed by the parties in their joint motion. The information in connection with request 2.1 shall be maintained as confidential and not subject to disclosure unless otherwise ordered by the Commission or by the presiding officer of the Commission during a hearing. I further move that the Commission hold any and all deadlines related to the motion to compel filed by CCL SACE on September the 7th, 2023 in abeyance and dismiss the motion to compel as it is resolved by this joint motion. So moved.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Thomas. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Thomas.
Aye.
Commissioner Justin Williams.
Aye.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
And I vote aye. The motion carries.
Madam Chair, that completes the utilities agenda before the Commission. Moving on to the motor carrier agenda, items numbered 1 through 3 in Part A are requests for new Class C certificates. Staff recommends that these items be taken together, and I will review them for the Commission. Item number 1 appears in docket number 2023-299T, which is the application of Wilder Taxi Limo Service, LLC, for a Class C charter certificate. Item number 2 is in docket number 2023-300T, which is the application of Spiritual Hands Transportation, LLC, for a Class C non-emergency certificate. Item number 3 is in docket number 2023-302T. This is the application of Teflon Industries Transportation Services, LLC, for a Class C charter certificate.
Commissioners, we've heard agenda items A1 through A3 on the motor carrier agenda as identified by Mr. Scarborough. Is there a motion?
Madam Chair.
Commissioner Justin Williams.
Madam Chair, fellow commissioners, I move that the Commission approve the applications for Class C certificates and items numbers A1 through A3 as listed by Mr. Scarborough. So moved.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Justin Williams. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Commissioner Justin Williams.
Aye.
Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams.
Aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
I vote aye. The motion carries.
In Part B of the transportation agenda, we have one request for an extension of time. This item is in docket number 2022-382T, which is a request from LBS Transportation, LLC, for a 9-month extension of time to comply with Commission rules and regulations.
Commissioners, with regard to transportation agenda item B1, is there any discussion?
Chair
Excuse
Belzer,
me,
I'd like to make
is
a
there a
motion.
motion on B1? I apologize. Commissioner Carol Lee Williams, thank you for keeping me straight.
I move that the Commission grant the request of LBS Transportation, LLC for an extension of time until December 14th, 2023 to comply with Commission rules and regulations. LBS Transportation, LLC's application for a Class E non-emergency certificate was granted by the Commission Directive Order Number 2022-812 issued on December 15th, 2022. This extension until December 14th, 2023 allows LBS Transportation, LLC a period of 12 months from the directive order date of December 15th, 2022, to come into compliance. If the company has not come into compliance by December 14th, 2023, LBS Transportation LLC may file a new application with the Commission when the applicant is ready to comply with the Commission rules and regulations. I so move.
Thank you, Commissioner Williams. Commissioners, we've heard the motion from Commissioner Carol Lee Williams. Is there any discussion? Hearing no discussion, we will proceed to a roll call vote, starting with Commissioner Carol Lee Williams,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Justin Williams,
Aye.
Vice Chair Powers,
Aye.
and I vote aye. The motion carries.
In Part C of the transportation agenda, we have one request to suspend a certificate. Item number 1 is in dockets numbered 1998-425T and 2000-491T. This is a request of Eastside Transportation Services Incorporated for a request to cancel Class C Charter Certificate number 6650-B and Class C Charter Bus Certificate number 0113.
Mr. Scarborough, I would just like to clarify that this is a request to cancel, not suspend, right? I think it was read correctly. It's just the title was originally said suspend, and believe me, I get mixed up on my words all the time.
It is to cancel. Yes, ma'am.
Thank you, sir.
Thank you.
And for your graciousness as always. Commissioners, we've heard transportation agenda item C1 is identified by Mr. Scarborough. Is there a motion?
Madam Chair,
Vice Chair Powers?
I move the Commission grant the request of Eastside Transportation Services Incorporated to cancel its Class C Charter Certificate number 6650-B and to cancel its Class C Charter Bus Certificate number 0113. So moved.
Thank you, Vice Chair. Commissioners, we've heard the motion from Vice Chair Powers. Is there any discussion? Hearing none, we'll proceed to a roll call vote, starting with Vice Chair Powers.
Aye.
Commissioner Carol Lee Williams,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Justin Williams.
Aye.
The chair votes aye. The motion carries.
In Part D of the transportation agenda, we have a petition to revoke certificates of certain motor carriers. This item appears in docket number 2023-196T, which is a petition from the Office of Regulatory Staff to revoke the certificates of certain motor carriers for non-payment of registration fees and/or failure to maintain and file evidence of insurance.
Commissioners, we've heard Mr. Scarborough identify transportation agenda item D1. Is there a motion?
Madam Chair,
Commissioner Caston is recognized.
I move that the Commission grant the petition of the Office of Regulatory Staff to revoke the certificates of certain motor carriers listed on revised exhibits A, B, and C for non-payment of registration fees and/or for failure to maintain and file evidence of insurance.
Thank you, Commissioner. Commissioners, we've heard the motion from Commissioner Caston. Is there any discussion? I believe this was the hearing that was conducted last week with the Office of Regulatory Staff on the petition.
Yes, ma'am.
Hearing no further discussion, we'll proceed to a roll call vote, starting with Commissioner Caston,
Aye.
Commissioner Thomas,
Aye.
Commissioner Justin Williams,
Aye.
Vice Chair Powers,
Aye.
Commissioner Carol Lee Williams,
Aye.
Commissioner Irvin, did I skip you? Or
It's
did I?
okay, I vote aye.
I apologize. Excuse me.
No problem.
Is that everybody? And I vote aye. The motion carries.
Madam Chair, this concludes all business notice before the Commission today.
Thank you, Mr. Scarborough. As that concludes our business, I will note that our next Commission business meeting is scheduled for Thursday, September 28th at 2 p.m. And with that, we are adjourned. Thank you.